Hi, this is Hannah, and you're listening to the University of Chicago Public Policy Podcasts. You're listening to Root of Conflict, a podcast about violent conflict around the world and the people, societies, and policy issues it affects. In this series, you'll hear from experts and practitioners who conduct research, implement programs, and use data analysis to address some of the most pressing challenges facing our world. Root of Conflict is produced by UC3P in collaboration with the Pearson Institute for the Study and Resolution of Global Conflict, a research institute housed within the Harris School of Public Policy at the University of Chicago. How is law understood and used by different actors during political transitions to achieve peace? In this episode, we speak with Professor Louise Mallinder, a professor in the School of Law at Queen's University Belfast and faculty affiliate of the Pearson Institute. She has a long-standing and internationally recognized expertise in amnesty laws through extensive writing and the creation of the Amnesties Conflict and Peace database. She works as part of the Peace and Conflict Resolution Evidence Platform led by the University of Edinburgh and funded by the Foreign, Commonwealth and Development Office. Professor Mallinder's teaching focuses on international human rights law, human rights practice, constitutional law, and transitional justice. We discuss how amnesties can be granted without compromising justice, the intersection of law with other disciplines in academia, and Professor Mallinder's perspectives at large on the field of transitional justice.
Hi, I'm Natalia Zorrilla. I'm first year Master's in Public Policy student and also a Pearson Fellow, and happy to be here.
Hi, I'm Louise Mallinder. I'm Professor of Law from Queen's University in Belfast, and this year I'm the Posen Professor at the University of Chicago and a faculty affiliate at the Pearson Institute.
Hi, I'm Isabella Nascimento. I'm first year Master of Public Policy student here at the University of Chicago and also a Pearson Fellow.
And I'm Hannah Balikci. I'm a second year MPP student here at Harris, a Pearson Fellow, and the producer of Root of Conflict for this year. So thank you for being in studio with us, Professor Mallinder.
Thank you very much for inviting me. I'm delighted to be on Root of Conflict.
Okay, so I will start with the introduction here. I would like first for you to introduce yourself and your work.
Okay, so I live and work in Northern Ireland, in Belfast, which is the capital of Northern Ireland. And as I'm sure many of your listeners know, Northern Ireland is a devolved region of the United Kingdom, but it's a place where its constitutional status is contested. There's a proportion of the population who identifies British and would like Northern Ireland to be part of the United Kingdom, and there's a proportion of the population who identifies Irish and would like Northern Ireland to be reunited with the rest of the island of Ireland. This grievance was one of the central factors in a 30-year armed conflict in Northern Ireland from 1968 to 1998, which in itself was one phase of violence in a much longer history. Since 1998, Northern Ireland has had a successful peace process. There hasn't been a return to armed conflict. There's still a lot of work to be done, but nonetheless the progress has been really significant. And I live and work in that space, and so I think that to a large degree influences what I do. So I work as a law professor, but I work in the field of transitional justice, which is an area of research and practice that borrows from different bits of international law. International humanitarian law, international human rights law, international criminal law, but also looks at how those legal regimes play out in very challenging political environments and at times where the law itself is undergoing reform and changing. So I think working in Northern Ireland, working in a space where there's a density of people in academia and in civil society who have huge expertise in this and have it as a lived experience, I think really animates how I think about many of the challenges of transitional justice.
Thank you very much. Now a follow-up question. How has your research, this means interests, areas, or disciplines, evolved over time?
That's a great question. I think I started out at university by studying a degree in economic and social history and politics. at that point, I hadn't been grown up in Northern Ireland. I'd moved there and I was interested in learning more about the place I was in. And so I found myself drawn to modules in Irish history, but also modules in deeply divided societies and particularly the Middle Eastern politics. And so as part of my undergraduate studies, I did my dissertation on the occupied Palestinian territories, and I did voluntary work in the West Bank for a period of time. So I was writing about the settlements. And so I think that brought me into trying to understand much more about what happens in conflict spaces. And so then I moved into law, thinking law had practical tools for how we grapple with some of these dilemmas. That's why I did a master's in human rights law and then a PhD in law. And I think that background shapes the type of legal questions I'm interested in and the way I approach law. So I tend to think of law from an interdisciplinary perspective. Now I'm a law professor, but I work in an interdisciplinary institute, and I want to understand ideas about how law intersects with peace, how, thinking about perhaps how in transitions from conflict to peace, law shapes the types of negotiations that are had, the types of bargains that are reached, how lawyers or legal institutions acting in those processes can shape particular outcomes. I'm also interested in how understandings of law shapes people's visions of what the peace should look like, both while the conflict is ongoing and afterwards. I'm also interested in how law shapes how people imagine what justice looks like and what sort of harms they see and don't see during conflict periods. And in particular, how law can work to both reveal or conceal different types of human rights violations that happened in the past. And so these are the types of questions that gradually, from my different degrees and then into my academic life, I've been exploring in different projects. So some of them have involved looking at particular transitional justice mechanisms like amnesty laws in different countries around the world. Some of them have involved looking at different cohorts of transitional justice actors. So in recent years I worked on a project about the role of lawyers as political actors in different transitional societies. I'm also interested in international law as well, broadly, so how these norms are formed at the international level and trickle down into different transitional states.
So could you please define amnesties for those who are not familiar with?
Sure. It's a great question because amnesties are a deeply politically loaded term, and often in contexts you see the word amnesty being used to describe different types of measures that people are uncomfortable with or resistant to. And I think what complicates it even further is there's no international definition of what an amnesty is, and the domestic legal systems of different countries have different approaches to how they apply amnesties or how they use that term. But in my research, I tend to think of it as measures that apply before somebody is convicted. And they operate generally to prevent criminal investigations, prosecutions, and convictions. So that's not to say that crimes can't be investigated by truth commissions or by other mechanisms, but an amnesty blocks individual criminal responsibility.
And now, could you give us one example of a conflict that illustrates some of the concepts, can be the concept of amnesty, of your work in academia?
Sure. Illustrates the concept how, just different examples of how amnesties have been used or why? Or
Yeah. Or a conflict that this has been a debate on?
Well, I think, to be honest, there are debate in most conflicts around the world. In my database, I created a database of all the amnesties I could find around the world since 1945, and I've published a subset of that relates to conflict settings. And I found that out of the hundreds of amnesties I've identified, about 75% of them since 1990 have been in response to conflict. When I tried to track that against states in the world that have had armed conflicts, I found that almost over 70% of countries that have had armed conflict have used amnesties in some form during their transition from conflict to peace. And about half of those countries have used amnesties for serious international crimes or human rights violations. And so they're a very prevalent tool. in response to conflict situations. But I think what's always endlessly fascinating for me is thinking about how differently they're used in different places, perhaps because of different norms and understandings around justice, different political balances of power at the time of transition, and also the backdrop of the nature of the violations and other justice responses that have been achieved. And so, I think it's common. I think what influences me is that a lot of the literature on amnesties, I think, has been heavily influenced by the practice of amnesty laws in South America. So some of those are conflict settings, some of them are more commonly understood as transitions from dictatorship. But by and large, in the 70s, 80s, early 1990s, in that part of the world where amnesties were used, they were granted very broadly to cover all serious human rights violations, and they tended to be unconditional, by which I mean if you were a perpetrator of serious human rights violations, an amnesty would be declared, you would just benefit from it, and you'd have to make no effort to contribute to peace, democracy, or addressing victims' rights. So they're deeply problematic amnesty laws, and I think they still shape some of the universal understandings of amnesties and their relationship with law. But I think what's been interesting is that over a number of years we've seen, particularly influenced by the South African experience of amnesty and truth, that amnesties can quite often be conditioned on trying to contribute to peace and reconciliation and victims' rights. So the South African Truth and Reconciliation Commission is the best known example of this. And in this context, after the end of the apartheid regime, the new government coming in set up a Truth and Reconciliation Commission. And in this legislation, it provided that the Truth and Reconciliation Commission had the power to grant amnesty for political offences, with political offences being understood as including serious human rights violations. But this was not an unconditional amnesty. So if people wanted to avail themselves of this, they had to apply. There was a formal written application process, and then many of them had to come in and give testimony. For the most serious human rights violations, this was televised testimony in public hearings, and victims could take part in those hearings. They could have legal representation, they could ask questions, and they could make statements about how these violations had impacted upon them. And this was meant to contribute to not just helping your victims be able to get some of the answers they need in their individual cases, but building a clearer picture of the causes and consequences of the violence that happened during the apartheid regime. And so it's very different from a completely unconditional amnesty that completely closes the door in the past. So there are a lot of different measures that we see. And I think today, roughly equal numbers of amnesty laws introduced after or during or after a conflict tend to cover serious human rights violations, and many of those are conditional in different ways, either on people contributing to security through disarmament, demobilization, on recidivism, or through contributing in different ways to addressing victims' needs to truth and reparations.
Yeah, thank you. I think that was a great overview of your work in general terms, but how do you define the conditions under which amnesties can be granted in post-conflict settings without compromising justice?
That's a difficult question. And I think what I'm trying to do in my current research is investigate that more. So I think there are different positions we see today in statements about international law and in academic literature about when amnesties can be used and how far law restricts their use. So the United Nations, for example, for a long time has said there can be no amnesties for international crimes and serious human rights violations. It's written into resolutions from the UN General Assembly and Security Council, as well as a number of UN policy reports. And that position has been influential and has been echoed in the case law of some international courts. But I think what's been interesting for me is I see that not all courts agree with that. So in particular, in 2020, the Appeals Chamber of the International Criminal Court in the Gaddafi case said the international law on the status of amnesties is still in the developmental stage. So they're saying it's still unsettled. The Inter-American Commission on Human and People's Rights has said, well, there is a norm prohibiting amnesties, but it only applies, or amnesties for serious crimes, but it only applies to unconditional amnesties. So for them, they're like, conditional amnesties are permissible even for serious violations. It's just unconditional ones that are not. Other cases have pointed to the possibility that amnesties introduced at the time of peace negotiations need to have more flexibility around them, recognising the difficult circumstances that those decisions are taken in. And so what I'm finding is actually there isn't a clear answer at the moment about where amnesties can be used or what sort of restrictions there are on states. And that's what I'm trying to research. And I think what we see, the reason we see these differences and divergences in different judicial opinions is because they're using different methodologies to identify if these legal rules exist. The key difference that you see there is how much weight they attach to what states are actually doing. So some courts tend to look at written texts. They will look at soft law standards, principles and guidelines developed by the United Nations or UN General Assembly resolutions. They will look at treaties that require prosecutions of serious violations and infer from those that if an amnesty stops prosecutions, then it must be impermissible. But what they don't do is look at what states are actually doing. And that matters because traditional perspectives to how we understand customary international law, which is one of the sources of law, or how we interpret international treaties, means that state practice should be one way of thinking about that. And so while all the other sources that courts are looking at are important and valuable, I think they should be looked at alongside state practice, but that's been missing from a lot of the jurisprudence at the moment. So that's what I'm trying to investigate at the moment, using my database and other empirical data that's out there. And I think what I'm finding is that the state practice is quite mixed. It's still, the work is still emerging. I'm still halfway through writing the book. But I think it's hard to say there's a widespread state practice in terms of rejecting amnesties for international crimes.
Well, you mentioned how different international courts interpret the law, and I want to talk specifically about the ICC, the International Criminal Court. It has faced criticism from primarily prosecuting cases in Africa since its establishment with the adoption of the Rome Statute in 1998. In your opinion, what steps should the ICC take to broaden its prosecutorial reach in other regions of the world?
Okay, thank you very much. So I think the first thing to bear in mind when we think about the court, where the court exercises its jurisdiction, is that there are constraints in the Rome Statute. Firstly, the court can only exercise jurisdiction over places where states that have ratified the Rome Statute or have issued a declaration to do so, or over places where the UN Security Council authorizes them to do jurisdiction. So we have those sort of territorial constraints. So there are parts of the world, including quite powerful states, where the ICC does not have any jurisdictional reach at the moment. Then after we think about those contexts, there's also different triggers for cases coming before the court. So there needs to be a state referral or UN Security Council resolution, or the prosecutor needs to exercise their own jurisdiction, their own initiative to investigate somewhere. So those place some substantial constraints about where the court can look. I mean, it has a lot of jurisdiction across African countries because African countries have ratified the Rome Statute, perhaps more than countries in other parts of the world, particularly in Asia. So I think that's one reality that we're seeing differences. And many of the African cases came before the court because those countries self-referred them. And I think there are, or because the Security Council referred them as well, is another reason why some of those cases came before the court. But I think the ICC in recent years has tried to diversify its jurisdiction. So if you look at the cases where it has preliminary examinations now or open investigations, there are a number of contexts in Asia, in South America, where it is actively investigating crimes. There are problems with how that's progressing. Its track record of investigating crimes against more powerful countries like the UK or the US perhaps raises some questions. There are also, I think at the moment, there are a lot of comparisons being drawn to how the court has responded to the situation in Ukraine and the situation in Palestine, in Gaza. But that's an evolving context. And I think there are differences between the court being able to get into Ukrainian territory and work with the cooperation of the state to investigate and document the human rights violations and what's happening in Gaza, where the ICC investigators can't get in and investigate at the moment. So I think there are differences in challenges, but I think the court is trying to broaden its jurisdictional reach. I think with the question of amnesties, though, that raises different issues. I think there have been a number where African countries have pushed back against the ICC at different points over the last decade or decade and a half. There's been kind of particular issues that have animated that. Head of state immunity is one key issue that I think has been a fault line between them. But also African Union member states have talked about the risk of the ICC intervening in active peace process situations, and thinking they should hold off a little bit, or think about how their interventions might influence the outcomes of peace or make peace more difficult to achieve. That was something that was particularly discussed in relation to the ICC's investigation in Uganda during the Juba peace talks in 2006 to 2008. There, an amnesty law had been introduced in 2000. It was an open-ended amnesty. It was being renewed each year, so it was still active. And that was designed to encourage rebel groups from the Lord's Resistance Army and a number of other rebel groups that are active in Uganda to surrender and disarm. While the peace talks were happening, victims groups in Uganda who had lobbied the Ugandan government to introduce the amnesty law started lobbying the court to say, we don't want you we want to keep the amnesty process. We don't want the court to interrupt this. I mean, part of that, I think, was animated by their desire for peace. They wanted to bring the conflict to an end. I think it was also a product of the fact that many of the people who'd fought in the LRA had been forcibly recruited, and many of them had been forcibly recruited as children and made to commit awful atrocities. And I think those communities, in recognition of it, were privileged, wanting to have those people who'd been forcibly recruited returned home and to enable them to reintegrate. But I think also running through a lot of those discussions was the sense that the communities in northern Uganda had their own understandings of justice that weren't criminal justice. They had traditional rituals to do with repairing harms that were committed, to do with reintegrating people when they come back. And they felt that those mechanisms could be applied to the crimes that had been committed during the conflict in ways that would help reintegrate the offenders and help bring a sense of justice to the affected communities. And so they were asking, could we use these forms of justice instead of criminal justice that might preclude it or might prevent people coming forwards and surrendering. At that point, the court didn't give too much weight for those situations. I mean, and that's something they could consider more. I mean, I've been interested in recent years that in a very, very different context in Colombia, there the International Criminal Court was perhaps a bit more cautious when it came to disrupting the peace negotiations that were going on between the Colombian government and the FARC guerrilla group leading up to the peace agreement in 2015, 2016. And there, while it's not a traditional indigenous form of justice, what has been proposed is kind of a tiered approach that allows for some forms of criminal prosecutions, but allows for prosecutorial strategies that recognise that some offenders will be prosecuted and some will not, given the scale of the atrocities. And it also recognises that where people are prosecuted and convicted, there's scope for leniency in how they're punished. So there's alternative sanctions, there's reduced sentences, and the International Criminal Court has approved those measures. It said it's closed its involvement in that site, saying that they could be in compliance with their own statute.
Thank you. I think you brought a really important point about the international system and how it actually needs states to cooperate in order to function well. Mm-hmm. So based on your research, what are key lessons or recommendations you would offer to countries undergoing political transitions and considering amnesties?
Yeah, so I'm just thinking at the moment I live in Northern Ireland, and we spent ages trying to give lessons to the British government over how to deal with some of these issues, and they have gone in the opposite direction and have introduced what is largely quite a broad amnesty for serious offences committed during the 30-year conflict in Northern Ireland. It's notionally conditional. but not in much of a substantive sense. And certainly, there's no guarantee that any information that's provided under that scheme will filter its way back to victims or to Northern Irish society. So it's a problematic form of conditionality. So I guess the first thing I would say is don't look at what Northern Ireland's doing right now. This instance, the UK is not a good model to draw upon. I think that when states are approaching this, I think they should look at, as a lawyer, I guess law is kind of where I started thinking about it, and thinking about the range of human rights obligations that they have under different treaties and international humanitarian law as well, and looking at those things holistically and recognising that all of those conventions create obligations for states to prevent further violations, which is connected to the right to peace. So that is part of the conversation. And that, the states have duties to investigate, to provide, to repair harm. And these things can all be understood in different ways and adapted to different contexts. And so while I think international law provides a framework that should think about what are our obligations and how do we balance them against each other, harmonise these different duties in ways that tries to be constructive in terms of delivering peace, I think also recognising that there is scope within that for thinking creatively about what's feasible within those countries and what ideas of justice really will deliver for people on the ground in a way that's feasible at the time of the transition. So I think I don't think there's a one-size-fits-all approach. And I think generally in my work, when I go to different societies and they ask me about what form of amnesty they should have or not have, I tend to answer by asking them different types of questions. Well, what is it you want to achieve? Is this about trying to get rebels to disarm? Is this about trying to get answers about the past? Is this about trying to bring different communities together? Whether an amnesty is needed at all is a particular question. And so I think there's lots of things to think through, and it's rarely a choice between an amnesty or not an amnesty, but it can be about, what is the capacity of the state to deliver criminal justice? How much does that resonate with the community? And how do we fit that alongside the other needs that we have to achieve at this point?
I think that gives a good transition into talking about the conflict and peace database that you said you've alluded to that you're building. I think I have two questions. One is, could you explain the main objectives of the database and how it's structured to facilitate research and policymaking? And then maybe just building off of the last point before you go into that, is there an amnesty or transitional justice program or process that you found has been particularly effective? And could you go through what the main points of that were? And I understand the localization of every amnesty and transitional justice process, but was there one that you consider like a success, or they're all different obviously in each context, but one that you think is a good example to point out to people?
Okay, so I guess on that, it's a difficult question because amnesties, I think, are introduced for a number of different goals. Actually, coincidentally, this weekend for a conference paper I'm doing next month, I started looking through amnesty laws, picking out how those laws communicate their own objectives, what they say they're trying to achieve. And many of them talk about peace, obviously. Many of them mention reconciliation, and it's understood in different ways, like national unity or forgetting. Many of them talk about development, talk about economic reconstruction, talk about addressing inequalities. And those are quite different objectives for an amnesty process than we don't often see in the literature. Some of them also talk about the goal of the amnesty being to encourage combatants to disarm and reintegrate. And so that speaks to me about these are all quite different measures. If you want to understand how successful an amnesty is in encouraging rebels to surrender and reintegrate into society, well, there might be ways of tracking that. Usually there are some sort of administrative functions that are involved in overseeing those processes, and you can have numbers and you can have a think about how this actually worked. I think in practice there's a lot of amnesties that do that. Sometimes the effectiveness is challenged by slow implementation by the state. So they'll say, yes, we are going to, we'll get an amnesty, but also we're going to provide you with certain measures of security or certain support to reintegrate yourself into society. And those other support structures come late or don't come at all, and those promises aren't met. And sometimes that dissuades people then, the rest of the combatants from coming forwards. And so the success of the amnesty may not be about the idea of the amnesty, but it can be about how it was implemented afterwards. Where amnesties have goals to achieve peace, that the success of that might depend on how you understand peace. I think a lot of scholars, a lot of the literature that's out there is trying to measure the impact of amnesties in conflict occurrence. And so there are a number of international relations scholars who've published work on that in the last few years. Those studies are really interesting. They all kind of think about amnesties in slightly different ways. They think about peace in slightly different ways, and they've come up with slightly different results. Many of them say that an amnesty introduced as part of a peace agreement does have a positive outcome in peace. So that's one measure. Does the main armed conflict recur? And you could measure that and say, well, actually, there's quite a lot of cases around the world where an amnesty was part of a successful transition to a peaceful landscape. Last week I was teaching my students about Sierra Leone, and that's a context where there was a peace agreement in 1999 where there was a broad amnesty enacted within that agreement and a truth commission. A couple of years later, the Sierra Leonean government asked the United Nations to help them set up a hybrid court, the Special Court of Sierra Leone, to try as the leaders of the main armed groups that have fought in that conflict. So that court indicted 13 individuals and convicted 9 of them. But the thousands of other offenders in Sierra Leone who had committed very serious violations benefited from the amnesty scheme. It was part of the terms and conditions of the disarmament and demobilization program that they would get amnesty as part of that. And I think what's really striking for me is that at the time of that peace agreement, Sierra Leone had profound challenges. It had a very weak state. There was little confidence in public institutions. It had very little financial resources to draw upon. Heavily indebted as a nation. There were the rebel groups were quite powerful within the society, and the scale of the violence that had happened is jaw-dropping. It was really brutal crimes committed against civilians. But Sierra Leone is now the 47th most peaceful country in the world.
Oh.
3rd most peaceful country in Africa. And so whether that is to do with the amnesty or to do with the successful demobilization and reintegration or to do with the Truth Commission or the Special Court of Sierra Leone, often it's a combination of all of these things that can make a big difference. And political will, I think, is a big part of it in many of these societies. So I think what the outcomes of an amnesty are, what a successful amnesty is, depends on what you're thinking of, what the amnesty is intended to achieve.
Got it. Yeah, that's very helpful. I think going off of some things that you've already built upon in this interview, could you explain the main objectives of then creating the Conflict and Peace database, what you're tracking, how it's structured to facilitate your research and research of others, and policy making that comes from looking at these commissions?
Sure. I mean, it began during my master's dissertation. So that's when I started looking at amnesty laws. The year between my undergraduate and postgraduate studies, I worked as an editorial and research assistant in Brussels in Belgium, and my job partially involved working on an access database. So I became familiar with these tools as ways of organising data. Then I came back to Northern Ireland and I started working on amnesties for a master's dissertation. And I was reading all these different examples of amnesties in the literature and needed some way to organise my own thoughts. So it started out as quite an elaborate table in a Word document. And then as it got bigger, I didn't expect to find as many amnesties as I did. At the end of my master's thesis, I can't remember exactly, but I probably had less than 100. And I was like, that's loads.
Yeah.
That must be nearly all of them. But then I ended up doing my PhD on that, and the project started getting bigger and more complicated. And so then I had to teach myself how to create an access database. And by the end of my thesis, I think I had over 500 amnesties introduced in that period. So it really spiraled beyond what I expected. But what I was doing, deliberately trying to systematically capture those things, was a couple of things. I think, and it was always intended to be public at the end of that research. It took me a while to get it online, but I always kind of wanted to put it out there. And I think the reasons were because, as I mentioned a little while ago, I think much of our understandings of amnesty laws are shaped by the experiences in South America, and then after that, the experiences in South Africa. But they are kind of two very, very different types of amnesties, but they're not representative of all the different diverse forms of amnesty that are used around the world. And so part of what I was trying to do was trying to expose all those differences and think about the different design choices that are available to states, and get people to start thinking about those different measures. I think too, also as a lawyer, what I wanted to try and understand was patterns in how states are doing this. And the reason is that international law comes from either states signing up to international treaties, or it comes from states engaging in particular practices because they think they have a legal obligation to do so. That's customary international law. And the case law of the International Court of Justice says for something to be a rule of a customary international law, there needs to be a widespread state practice. Right. Engaging in certain behaviours. And so using my database gave me a way to count that, to track it, to be able to think about how this was evolving over time, whether, and international law allows for, regional customs to exist alongside global ones. And so I could look at, what's different about amnesties in South America compared to other parts of the world, or are there differences around how different regimes are using amnesties? And so I could use the data to try and track all those differences, and then use that to talk about what the status of international law is.
Great, thank you. I think you've said this before, but like the idea, right? The idea of an international norm for amnesties, and if so, are they binding, right? If there's a norm, do the states actually stick to them? How has the database been used? Do you have any information on how it's been used, either through research or by policymakers or international bodies in shaping these responses to ongoing conflicts? Mm-hmm. Do you think there's a binding norm, or is there still is it still forming? I know different places have said different things in terms of the norms for amnesties.
Well, I'm only partway through the book that I'm investigating.
Okay, yeah.
So I don't know yet where I'm finally going to end up on that.
Yeah.
The work that informs the database that I have written up in various ways has been used quite widely. So I haven't looked for a while to kind of track how people are using it, but I know when I looked before, comments I've made about the use of amnesties, how their frequency, where they're used most often, have found their ways into judgments of some of the international courts or submissions to them from different actors. It's been used by the Grand Chamber of the European Court of Human Rights, and they were talking because it informed an intervention that I and others wrote in terms of the Marcus case. It's been cited in different policy reports at the UN and other bodies. And so that type of practical resource, I think, is something that there is an appetite for among those who are working on these issues and trying to make sense of them. But I'm not sure kind of recently recent examples of it. When I'm framing the research questions for my book, I ask, is there a norm? And if so, is it an emerging norm of international law, or is it a fully established legal rule that has binding legal effects on states? Or is there no rule at all? Or because I think before the recent developments of the UN position, and that's been taken up by a number of other actors, amnesties are prohibited. What existed before that was the rule in Additional Protocol 2 to the Geneva Conventions, Article 6.5, that called on states to grant, or encouraged them to grant the broadest possible amnesties at the end of our internal armed conflicts. So that was the old rule. Now there's a question about whether there's this new rule to say states are encouraged to grant amnesties at the end of armed conflict except for international crimes and serious human rights violations. I still have to do more work clarifying in my own head about what the significance is of saying if something's an emerging norm. Is that a soft law, something that states can do? They're not violating international law if they refrain from granting amnesties, which I think is definitely the case, of course. But whether the states feel they have a binding legal obligation not to grant amnesties for international crimes, I think it's going to be harder to find overwhelming evidence that that's the case. I can certainly find evidence that some states are moving in that direction, that have been willing to exclude international crimes from peace agreements, from domestic legislation, often because of international pressure from the United Nations or other actors or conflict mediators. But I think many states are still willing to grant those amnesties. And what's interesting for me too is that if something is a binding international legal norm, international law and international relations scholarship would suggest that if that binding, breaches of that norm should be an exception, and where states violate that norm, they should expect pushback from other states. They should expect criticism, condemnation, some sort of outcome. And I think what I'm finding when I'm trying to look at that, I've been looking at where states sign up to peace agreements or the types of recommendations they give each other in the Universal Periodic Review. And what I'm finding, by and large, is states are quite silent about other states granting amnesties. It's not something that's triggering a huge amount of backlash. So if you look at the Universal Periodic Review, for example, in cycles 1 to 3 of that mechanism, which is a peer review mechanism run by the UN Human Rights Council, it's gone through 3 cycles over a number of years. And across those cycles, states have given each other 90,000 recommendations. So I thought I'd find loads about amnesties. When I searched through databases, there were 13.
Wow.
Yeah. So I'm not seeing big evidence that this is something that states are really pushing back as much as perhaps, I think where there is opposition to amnesties, it tends to come much more from the human rights community and for understandable reasons and come from the United Nations. But it's not something we're seeing states doing in terms of their relationships with each other very much.
Not even like naming and shaming?
Not with states who do it, not as much, no. I mean, there are examples where it is happening. So for my own context in Northern Ireland, the Irish government has recently taken the British government to court, or to the European Court of Human Rights, complaining about the Legacy Act. So that is one example where you state is very, very clearly pushing back against what they see as a very broad amnesty. But I think those types of responses are rare.
We wanted to understand, how do you see the intersection of law with other disciplines, such as international relations or economics or sociology, in enhancing the understanding of transitional justice and peace building?
Okay. I mean, it is a very broad question. Transitional justice as a field has always been a very interdisciplinary one. It began really from the work of political scientists studying the transitions in South America in the 1980s and looking at the circumstances that give rise to a political transition and thinking about the different dynamics of those transitions, whether they were negotiated or a regime collapsed, and kind of speculating about what that meant as an outcome. And that work by political scientists was accompanied by the work of academic lawyers and human rights actors who trying to ascertain what the legal framework is for these moments of transition. And I think it's interesting if you read some of the historical accounts of that period. Paige Arthur has an excellent article on it, but also some of the human rights actors involved have written quite reflective pieces on it. And one I particularly appreciated is a biography by Juan Mendez, who's a human rights actor, and he talked about how during the dictatorships, all the human rights mobilization was geared around naming and shaming. It was geared around calling on states to stop their abuses. But when the military dictatorships collapsed and the abuses did stop, then the human rights actors felt that naming and shaming didn't go far enough, given the types of abuses that happened. So they began to pivot and try and call for accountability. But there wasn't much, international criminal law wasn't as developed as it is now. International human rights law hadn't taken a turn towards criminal prosecutions that it did do in the subsequent years. So what you saw was an effort by lawyers working in this space to try and start interpreting treaties in different ways to try and say there are prosecutorial obligations on states where there have been serious human rights violations, and those ideas were then taken up by the different regional human rights courts in the United Nations. And so lawyers played a very strong role in pushing for the development of the field within a particular orientation, and they did so with human rights actors on the ground in some of the South American countries who had quite a rule of law, legalistic tradition within their societies. Over the years, I think the work in transitional justice has broadened out considerably, and I think for the better. So you have many different scholars from different perspectives looking at how to understand questions related to justice in relation to transitions. So you have criminologists bringing their insights about, well, what does it mean to prosecute perpetrators of serious human rights violations? How do we understand these crimes? How do we understand these actors? And what, does deterrence work in the same way in these settings, for example? What does retribution mean when you're talking about really serious violations? You have sociologists trying to understand some of the dynamics around how societies move forward, and different, ideas of historical memory and narrative, and thinking how does that filter into ideas of reconciliation, for example. Anthropologists will want to understand people's engagement with justice and how they envision it and what their cultural norms mean. And of course, there's a huge feminist literature running through all of it, and indigenous literature is increasing, and they're all bringing very different perspectives about what types of harms we need to see, what we need to address, and what justice looks like. So I think and a lot of that literature has been quite critical of the legalistic focus in the field of transitional justice. They think it's quite narrowly focused on serious physical violence. And what's been missing from that is a lot of the structural violence that is often a root cause of conflict and is often aggravated during the conflict. Often has much longer backdrops and different periods of victimization, including colonialization, that underpin it. And so they're trying to expose some of those longer term histories and the complex structures that feed into the violence, I think is really important for thinking about how do we prevent this happening again. So I think looking beyond law when thinking about transitional justice has been hugely important for giving a more complex and nuanced understanding.
I think that transition's pretty, no pun intended with transition, but I think that goes actually pretty well into the next question we were going to ask was, does transitional justice ever end? Like at the expansion of the field, is there a cutoff or a norm that is in existence when looking at this? Like if you're looking at the situation of actors who have either died or victims' descendants, looking at colonization as well, it's like, is there a sense that it ever ends? Or, I don't know if your thoughts on that, yeah.
I think when the field first began, there was definitely a lot of literature talking about transitions as really discrete moments, short moments of opportunity where everything had to be done quite quickly because either attention would wane or become difficult to kind of seize the moment, and that usually I think at that point transitionals were thought of as a period between the end of the old regime and perhaps the first democratic elections of the new regime. But I think very quickly, really, as the field evolved, I think that understanding of transition as something very short-term and discrete has been questioned. Yeah, I think today we see transitional justice being used for decades after crimes have taken place. So some of the earliest transitions were the ones in Argentina and Chile. And there, I think what we've seen is waves of transitional justice, where in the initial period after the military dictatorship, holding widespread prosecutions became quite difficult and was blocked by amnesties in both settings. But as situations changed within those countries, the political outlook changed, the legal institutions changed in terms of their composition, or the constitutions were rewritten. There were various things that happened that made it possible to reopen some of those criminal prosecutions, and so they're still going on in those contexts, even now, many, many years into the transition. So I think that's a common theme, that it does go on for a long time, and actually it changes as circumstances allow. In other contexts, I think what we see is perhaps people's expectations of what transitional justice should deliver shift as the transition goes on. So in South Africa, in the early years, there was obviously the Truth Commission with its amnesty process. There was a possibility of prosecutions for those who did not apply for amnesty or were denied it, and there was meant to be reparations coming out of that, although that was never, those recommendations of the Truth Commission were never fully implemented. What there wasn't was perhaps a broader look at the structures, the socioeconomic structures and structural inequalities in South African society as a result of apartheid. And so I think in recent years there's been much more of a pushback about that. And it's often framed as the unfinished business of the transition, things that were kind of put to one side, and people are asking for those things to be addressed. And so you do see that in different transitions, that demands evolve as more things become possible, or perhaps the limitations earlier on become much more apparent. So I don't think it ends. And I think in many contexts, actually, demands for transitional justice, we know now, cross generations, where they're not resolved, where they're not really addressed. Spain is a very commonly cited example of this, where there was the Spanish Civil War, then the Franco regime, then a transition that was characterized by a very broad amnesty known as the Pact of Forgetting. So there wasn't really much space for looking into any of the crimes that had happened. but since the early 2000s, there's been a push to kind of challenge some of those historical narratives, to exhume mass graves, to challenge the way that the Franco regime is remembered in the public sphere, and lots of efforts to kind of undo the past in that sense, even if it's not criminal prosecutions, but it's all still transitional justice. And a lot of that is being driven by descendants of those who were killed during the Spanish Civil War. And so if things aren't addressed, you can pretty much guarantee that those demands will not go away, that they will continue. But I think, for me, it's hard to fully... I think that a lot of the goals we think of as transitional justice are almost like ideal types. You know, I in the context where I live in Northern Ireland, whether we're still a transitional society, whether we're still in a peace process, is something that people debate. But I think people don't question that we still have problems, that our reconciliation hasn't gone as far as everybody would like, that our political institutions are still unstable, and that the past is one of the dividing lines there. And so I don't know what perfect reconciliation in Northern Ireland would look like, but I think it's something we can work towards and we can still make benefits for. And I think it's something that requires vigilance too, because you can be working towards something, but external political circumstances, like Brexit, for example, or other things that may arise in other societies, can cause regression, can cause tensions, can make things more challenging. And so it's something that states are on a journey towards these aspirational goals, but how people imagine those goals, how they're foreseen, and the journey can evolve over time, and the journey may not be linear.
We are now getting to the conclusion of our podcast. So if there was one paper or book that you would recommend to students of public policy, which one would it be?
God, I need to think about that.
It can be a podcast as well.
And you can name more than one too if you're
okay.
If you can't pick.
At the moment, I don't think there is one text in the transitional justice field that really gives kind of a how-to guide to address transitional justice. But there are some that give very practical guides for how to think about particular institutions. So I'm thinking of Mark Freeman's book on truth commissions and procedural fairness as an example of a really excellent book that kind of goes step by step between these are the things you need to think about if you're setting up a truth commission. So that's, you know, very, very practical tool. But if someone wanted a broader overview of the field of where it is today, I think there's a research handbook on transitional justice that's recently been edited by my colleagues in Queen's in Belfast, Cheryl Lowther and Luke Moffat, and that's an excellent resource because it covers a whole range of topics. So if anybody wants to know quickly, right, how do I think about this question, or the type of transition I'm working on is a transition from conflict or a transition from dictatorship, or I want to know how to address the involvement of women in a peace process, it would be kind of a one-stop shop to cover all the issues that you'd want to be having a look at. So I'd recommend that one.
Great, and I think this would be the last question. It's asked to every guest that we have in the podcast. So what is something you wish we would have asked you?
I don't know. You've been really comprehensive. I guess when I gave the talk the other week, somebody asked me what I think is going to happen next, or what happens with how geopolitics is affecting transitional justice. So maybe that one.
Mm-hmm.
So I think we're at a very interesting moment for the field of transitional justice. Since it emerged, it was always tied very much to the global legal order, and an idea that there was an expansion of legal norms and institutions, that we were moving towards an age of accountability. You know, you see this type of language being very, very clear in statements by the UN Secretary General, for example, but other actors as well. And a lot of that was premised on the sense that states were increasingly buying into these norms and increasingly supporting them. I think now we're at a moment where there's growing questioning of a lot of those assumptions. Obviously, globally we're seeing a pushback against the international legal order in different ways. We are seeing really egregious violations of human rights happening in different parts of the world, and the existence of international criminal courts sadly doesn't seem to be able to abate that suffering, or to even encourage combatant factions to refrain from particular types of violations. So I think that kind of perhaps challenges some of the ideas for what is feasible and what transitional justice can really achieve in those contexts. I think too, a lot of progress was made because of a trajectory towards more peace agreements. The conflicts were ending and there were going to be comprehensive peace agreements to be reached. That is less common today. I'm quite struck by how conflict mediators are saying we're going to see less of those big comprehensive peace agreements and more partial agreements, ceasefire agreements, humanitarian agreements. And that makes it harder to try and set up a comprehensive vision for what transitional justice should look like. So in some ways, I think that causes challenge. It causes concern that perhaps mechanisms or actors that have bolstered a push towards greater accountability aren't going to be as influential or aren't going to be as willing to act as they were in the past. And it's notable when you see kind of democratic states turning more towards authoritarianism or turning away from international human rights norms. That's something that causes alarm within the field. But I do wonder whether some of it could be an opportunity to address some of the challenges that people have been raising with the problems of legalism within the transitional justice field. I think in many societies where international legal institutions have not been able to intervene, what you see is a lot of energy and agency coming from civil society on the ground. You see people turning to different types of mechanisms, civil society documentation work, artistic projects, community-based justice mechanisms, creating ways of addressing these problems that are very much embedded in the local communities. And so some of that might actually, in the long term, be good for thinking about what does locally grounded transitional justice mean.
Thank you for listening to this episode of Root of Conflict, featuring Professor Louise Mallinder. This episode was produced and edited by Hannah Balikci and Nishita Karun. Thank you to our interviewers, Natalia Zorija, Isabella Pistana, and Hannah Balikci. Special thanks to UC3P and the Pearson Institute for their continued support of this series. For more information on the Pearson Institute's research and events, visit their website, pearsoninstitute.org, and follow them on Twitter at PearsonInst. Inst is spelled INST. Thank you. If you found this episode interesting, we invite you to join us for the 2024 Pearson Global Forum, Negotiations and Agreement. Join us on Friday, October 18th to hear from global experts as they discuss topics like the role of women in negotiations, speaking law to war, and other interesting panels around the theme of negotiations and agreement. This in-person and virtual event is free and open to all. You can find more information at thepearsonglobalforum.org.